The 3 Martini Lunch is brought to you in part today by 4 Patriots. Don't forget to go to 4patriots.com/martini to see all of their latest deals, including getting a free solar panel with the purchase of the Patriot Power Generator 2000X. And as always, free shipping on orders over $97. The Patriot Power Generator 2000X is what you want to have on hand whenever your power goes out, because you don't know how long it's going to stay out. So you want that fridge full of increasingly expensive food to be ready to go. Your freezer, medical devices, and so much more. It comes with 12 outlets, including 4 AC, plus 2 USB-C outlets to keep that phone charged 20 times faster than a regular plug. Also, don't forget about the last chance deal items on the Patriot Pure line, the UV phone sanitizer, UV wand, sanitation solution machine, and more. Visit 4patriots.com/martini to get your Patriot Power Generator 2000X with the free solar panel included. Plus, get free shipping on orders over $97. Save more and get peace of mind now by going to the number 4patriots.com/martini. That's 4patriots.com/martini.
Welcome to the 3 Martini Lunch. Grab a stool next to Greg Columbus of Radio America and Jim Garrity of National Review. 3 Martinis coming up.
Hey, really glad you're with us for the Tuesday edition of the 3 Martini Lunch. Jim Garrity, as you know, is still away, and back in his stead is Andy McCarthy, former Chief Assistant U.S. Attorney for the Southern District of New York, author of Ball of Collusion, and he is also a contributing editor at National Review Online, also a columnist there, and a Fox News contributor. Andy, welcome back. Good to have you as always.
Greg, always great to be here.
Andy, let's first talk about what happened yesterday at the U.S. Supreme Court. It's Murphy versus Missouri, and what a lot of people are calling one of the biggest free speech cases in a very long time. And this kind of follows on the heels of the Twitter files and the revelation that the FBI, the Department of Homeland Security, and basically the federal government pressuring social media platforms, big tech in general, to take down speech they consider disinformation or misinformation, largely about COVID or elections back in 2020 and that sort of thing. The District Court and the Fifth Circuit Court of Appeals have sided with those saying the government did violate free speech rights and pressuring the companies to take down those posts. Then yesterday, the court heard the government's response, the government saying that there has to be an adverse government action either done or threatened in the future, either to the person posting or to the social media platforms if they don't comply. And they say since that didn't happen, that the lower court rulings are not correct. The argument from the Louisiana Attorney General, who argued in favor of the lower court rulings, saying that you don't need that direct coercion. It's still a violation of the First Amendment. And if you want to confront speech you find incorrect, the solution is to confront it with more speech, not take away their free speech. And we can certainly talk about the larger context in just a moment. But the reason we're talking about this today is Justice Ketanji Brown Jackson and her comment being concerned about the government and its speech being curtailed in favor of individual free speech, which is a curious take. But here's how that sounded in open court on Monday.
So my biggest concern is that your view has the First Amendment hamstringing the government in significant ways in the most important time periods. What would you have the government do? I've heard you say a couple times that the government can post its own speech, but in my hypothetical, kids, this is not safe, don't do it, is not going to get it done. And so I guess some might say that the government actually has a duty to take steps to protect the citizens of this country, and you seem to be suggesting that that duty cannot manifest itself in the government encouraging or even pressuring platforms to take down harmful information. So can you help me? Because I'm really worried about that, because you've got the First Amendment operating in an environment of threatening circumstances from the government's perspective, and you're saying that the government can't interact with the source of those problems.
And just in case you forgot, here's Biden to remind you which justice that was.
Those are the words of Ketanji Brown Jackson.
So, Andy,
you couldn't resist that, could you?
I couldn't resist. I've been hanging on to that clip forever. I'm going to keep using that as long as she's talking. Andy, I thought the whole point of the First Amendment and the Bill of Rights was to hamstring the government, especially during times of national stress. But what did you make of her argument there?
Well, it's a terrible argument. And you're right, it is counter-constitutional. But what worries me, Greg, is that it's becoming a kind of a common conceit. When she made that remark, I was thinking, and I guess this is because I've been covering this for a number of months now, but, the argument in one of the Trump prosecutions, specifically the election interference case in Washington, and the haste of Jack Smith, the prosecutor, to get the case on trial, is based on this claim that the government has a right to a speedy trial. There seems to be on the progressive Democratic side, and this comes very clearly through its justices and judges who have been appointed from that camp, this whole idea that this array of rights that the Constitution recognizes for individual Americans somehow are rights of the government, when the whole point of the Constitution, as Barack Obama, another progressive Democrat, said in a very pejorative way, but he was right about this, that it's a charter of negative liberties. In other words, it tells you what the government cannot do to you. When we recognize that we have these rights, and by the way, it's important intellectually and in terms of getting our first principles down right, the Constitution doesn't give you these rights. The Constitution recognizes that you have these rights naturally. Like, for example, the Second Amendment, you often hear progressives saying that the Constitution gives you some right to carry firearms, and that's not true. You have a natural right of self-defense that the Constitution vouchsafes by recognizing it in the Second Amendment. But the point of the Constitution is to promote liberty, and that is, generally speaking, done by limiting what the government can do. So it's almost perverse to take the position that the government is actually empowered by these rights that are meant for individuals and has a voice at the table or an array of rights just like the individual person does. And of course, the reason that we recognize rights for individual people against the government is because the government is prone to abuse. It's necessary, but the framers saw it as a necessary evil for good reasons. The government is powerful as it is, which is why you need limitations on it and you need protections from it. If you're going to start to empower it as if it were a person with an array of individual rights, you have no chance against government abuse. And what I think is most unfortunate about this is a really hard issue. And I say this as somebody who worked in the Justice Department on national security cases. You want to have a situation where private actors feel like they can come to the government, and they're encouraged to come to the government if they see something that really is a potential, like a potential mass murder attack or a potential to do significant harm, whether it's the entire society or a select part of it. You want to create an atmosphere where that can go on voluntarily. See something, say something. As long as you're not ordered to say something, see something, say something is a good guideline. It's a responsible way of going about your life, trying to call on government when it makes sense to call on government in order to protect. But government doesn't have a monopoly. It's got the opposite in this system of saying what is misinformation and what is harmful information. We learn what's misinformation and harmful information by virtue of the contest of ideas in the public square, not because the government pronounces this is what COVID is, and this is what the effective remedy of COVID is, and this is what a danger is, and this is what a domestic terrorist is. The government doesn't get to do that. That's the marketplace of ideas, as Holmes put it. I hate to see Justice Jackson going down this road, because then it becomes an argument over principle, which gets us a little bit afield from what I think is the issue here, which is you want businesses to be encouraged to report suspicious activity and dangerous activity to the government. But you want to create that scenario without having the FBI show up at Twitter and say, pretty nice platform you got here. Be a shame if anything happened to it. And that's what the court was talking about yesterday when they say there isn't a direct threat of consequences. Well, who says there's not? In most cases, that's a jury question because it's not black and white. The Bureau doesn't come in and say we're in charge of enforcing the laws against espionage, and we think that you, by promoting these messages, may be promoting Russian disinformation. And if you continue to do it, we're going to come after you and investigate you and make your life miserable and maybe prosecute you at the end of the rainbow. That's not how this goes. What happens is the FBI comes in and they lay out like 8/10 of the situation, saying, we're worried about Russian disinformation. We're responsible for enforcing. If you're peddling Russian disinformation, it's always possible that somebody could say you are a clandestine agent of a foreign power. We're not saying that, but it could be said. And then they leave, and the general counsel that you've hired at your nice social media platform, who just happens to have been like the general counsel at the FBI in his former life, comes in and they meet in the executive suite and they say, what they're communicating to us is if we do what we want to do here, if we let this messaging go out, they're going to come after us. So we better not do it. And they suppress it. Now, the FBI can come back and say, we never directed them to do anything. But the way this game works is they lay out just enough to worry you about what they might do if you do what they don't want you to do. And that's what the problem is. And that's the chill on your First Amendment rights. And the fact that you can't put down in a clear way, this was the direct threat of subsequent consequences. If we did X, they were going to do Y. That's not how it works. That's not reality. So for Jackson, I think to throw into the mix this concept that the government has an array of rights is provocative in a situation where I think the last thing you want to be is provocative, because this is a situation where we want serious people to try to figure out what's the best way to open the lines of communication so that a business voluntarily can cooperate with the government, and we can have a line of communication without there being coercion involved. That's a very hard problem.
Very well said. And you also put your finger on a huge issue about the philosophy going on in the mind of Justice Jackson here, because as you suggested, this is not just some fringe element now on left-leaning folks in this country. This is mainstream now. We just saw this controversy a couple of weeks ago when Heidi Prisbilla of Politico was on MSNBC and said, these Christian nationalists are so insane, they actually think rights don't come from Congress. They think they come from God. And I'm like,
imagine.
That Thomas Jefferson, that radical Christian nationalist from the Declaration of Independence.
Yeah, but, it's interesting. If you go back to what Obama said, the whole thing about the Constitution being, he said ruefully, but accurately, the Constitution is a charter of negative liberties. It says what the government can't do to you. And he went on to elaborate that the failure of it is that it doesn't specify what the government must do for you. And the problem with that whole philosophy is the government doesn't have anything that it doesn't take from people. And when it takes, it redistributes. It takes something you have and gives it to somebody else. That's what it is. Now, they have a variety of euphemisms for it, but that's what government does. And the problem is, if that's your mindset, if you're saying we have to have a system where the government is responsible for doing things for you, like keeping you safe from bad messaging and keeping you safe from disinformation, not keeping you safe from hordes coming over the border in violation of our laws, but you might hear something that's provocative on the internet, right? And the thing is, if you're now going to say the government has an obligation to do things for you, that's just another different way of saying the government has rights, because the government has to have the ability to compel somebody to surrender something in order to give it to somebody else. So this whole idea that we're now going to sort of anthropomorphose the government. Is that the right word for it? We're going to turn it into a person who has the rights under the Bill of Rights just like you do, when the whole point of the Bill of Rights was to protect you from them, is, it's dangerous.
If you appreciate our founders and their founding logic, this might drive you to toss down a couple of drinks. But before you do that, take Z-Biotics, the pre-alcohol probiotic drink that'll make the next morning a little bit easier to manage. It's the world's first genetically engineered probiotic. It was invented by PhD scientists to tackle rough mornings after drinking. Here's how it works. When you drink, alcohol gets converted into a toxic byproduct in the gut. It's this byproduct and not dehydration or anything else that's to blame for your rough next day. Z-Biotics produces an enzyme to break this byproduct down. So just remember to make Z-Biotics your first drink of the night, then drink responsibly, and you'll feel your best tomorrow. So go to zbiotics.com/3ml to get 15% off your first order when you use 3ml at checkout. Z-Biotics is backed with 100% money-back guarantee, so if you are unsatisfied for any reason, they'll refund your money, no questions asked. Visit zbiotics.com/3ml and use the code 3ml at checkout for 15% off. Thank you, Z-Biotics, for sponsoring this episode and our good times. All right, Andy, on to our second martini today, also in the courtroom. This time we're headed up to New York City, and this is a piece you wrote for National Review Online as President Trump faces a $454 million civil fraud judgment up in New York. And you've mentioned on this podcast and in many columns about the dubious nature of that case brought by the New York Attorney General. It's obviously being appealed, but the penalty here is immense as well, despite the fact that no one claims they were defrauded here and the loan was paid back and all sorts of things. But now Trump says he can't post bond on the $454 million. He's asking a New York appeals court to stay enforcement of that civil fraud judgment for now. So, Andy, how does this work? What happens if he can't pay it, especially if the appeals court doesn't go his way? And what happens if it does?
Yeah, we have this is like a tick, tick, tick situation, Greg, because the way this works, there's a brief stay after somebody wins a judgment in a trial, during which the person is not allowed, the prevailing party is not allowed to enforce the judgment. In other words, like, it's not like the moment the jury comes in, you can take that verdict and run out and start seizing people's property, right? And the timeline in which your ability to collect on a judgment is suspended is roughly equivalent to the losing party's timeline for filing a notice of appeal and proceeding with that. So the idea is the appeal would be illusory if you lost all the property that was at issue in the judgment, and the law has to have a way of freezing your ability to freezing the winning party's ability to collect on the judgment while the matter is under appeal. That's all fine, but most of the time you want to make sure that appeal is not being done to delay. You know, the person who won a trial presumptively is going to win on appeal. That doesn't mean that happens all the time, but we have to figure, our presumption ought to be that if it was a full and fair trial, that the outcome at the trial is going to be upheld on appeal. And therefore, you want to make sure that a person who's lost the trial doesn't either dissipate his assets while you're supposed to be in this window where there's non-enforcement. And you also want to make sure that if the person is taking an appeal just for purposes of delaying the inevitable, that at least the losing party has to satisfy the court that the money is there to pay the victims of whatever, who are the reason for the judgment in the first place. This is an unusual situation because there are no victims. New York brought this case under a statute that's usually invoked in the consumer fraud area. And it's kind of like the concept behind a class action where, usually you have a bunch of people who've been harmed in some way, but the harm is minimal to any single one of them. So none of them has the incentive to bring a lawsuit, which is a very expensive proposition. So in that context, the law allows them to sort of gather together as a group and sue. This is the same idea. The state can come in here and go off against a company that engages in a pattern of deception under circumstances where there's no one consumer that has any, has the real incentive to bring an action. New York took that statute and applied it in the very different context of big dollar transactions where both sides are sophisticated financial actors, and it's expected that both sides will do their due diligence in dealing with the other one. And in fact, Trump's financial statements of financial condition, which were the nub of New York's case against him, actually had an admonition in them that told the other side, valuations on things like real property are very dynamic and can be subjective, and you should do your own due diligence. So it's not like anybody got, the wool pulled over them. So you have this very unusual situation where there are no victims. And the other thing is Trump is, I wouldn't say he's cash poor. He's cash poor at the moment because he's looking at judgments like he had to pay $100 million bond in the E. Jean Carroll case about 2 weeks ago, maybe less than that, to be able to stop her from enforcing while he appeals that. So now he's got this $500 million. I mean, it's $454 million, but it's $112,000 a day is being added to it in interest costs. So it's let's say he needs $600 million. Even a rich guy like him does not have $600 million in cash lying around, oddly enough. But what he does have is he's got a lot of fixed assets. He's got a lot of real estate. So I think at the end of the day, with this Trump fraud case, we're going to get down to the brass tacks of the Constitution, which is the Eighth Amendment, and there's an analogous provision in the New York Constitution, holds that excessive fines are against the law. You can't have them. You have a constitutional protection against them. To impose a $500 million, $454 million penalty is ridiculous under these circumstances. It's like sending a jaywalker to the electric chair. It's just nuts. So I think they will ultimately have a strong argument under that provision. But in the here and now, just to get in the door of appeal, you would think that the court would say, we're not going to make them post $500 million. That's unreasonable. Make them post something modest and put some clamps on them. This is the other unusual condition here. Trump has a lot of real estate in New York. It's not going anyplace. It's not like he could pick it up and move it someplace else. So put some restrictions on him in terms of of not being able to dispose of his assets that he has in New York, which he shouldn't want to do anyway, because then it's a fire sale and he won't get for them what they're worth, right? But New York shouldn't have to worry about Trump because the Trump properties are not going anywhere. And what we're not saying that New York is never going to get the money, but he gets to appeal. So, let him appeal, let him post something reasonable but not insane, and let the appeal proceed. Otherwise, you're telling people that they have a right to appeal, but it's illusory, because if you have to pay money that no one could pay in order to make your appeal meaningful, then it's not meaningful.
Well, let's talk about something way better than that, and that's meat. I know the left doesn't want us to eat meat, but I like to eat meat, and I especially love it when the Moink box shows up on my porch. I love their bacon. It's the best bacon I've ever had. I love the steaks. I love the chicken, and whatever else you order, which you do get to order what's in it, you will love it. Moink delivers grass-fed and grass-finished beef and lamb, pastured pork and chicken, and sustainable wild-caught Alaskan salmon straight to your door. Moink farmers farm like our grandparents did, and as a result, Moink meat tastes like it should, because the family farm does it better. Again, you choose the meat delivered in every box, like ribeyes or chicken breasts, pork chops, salmon fillets, and much more. Plus, you can cancel anytime. We love the Moink box here at the Columbus House, and I know you will too. Keep American farming going by signing up at moinkbox.com/martini right now, and listeners of this show will get free bacon for a year. That's 1 year of the best bacon you'll ever taste, but for a limited time, spelled MOINK box.com/martini. That's moinkbox.com/martini. All right, Andy, on to our crazy martini now. We need something a little bit lighthearted, unless, of course, you're looking for a good attorney in the state of Washington. That might be a little bit harder soon. Due to a task force created by the Washington State Supreme Court, you will no longer have to pass the bar exam to become a lawyer in Washington State. This is from the Spokesman Review newspaper in Spokane, Washington. So the court created this bar licensure task force, and the task force found that the traditional bar exam, quote unquote, disproportionately and unnecessarily blocks marginalized groups from becoming practicing attorneys and is at best minimally effective for ensuring competency. That according to a news release from the Washington Administrative Office of the court. So there are new ways now that you can become a practicing attorney in the state of Washington without passing the bar exam. One is that law school graduates can complete a 6-month apprenticeship while being supervised and guided by a qualified attorney, along with finishing 3 courses. Law students can become practice ready by completing 12 qualifying skills credits and 500 hours of work as a licensed legal intern, and upon completion of those requirements, they would submit a portfolio of that work to waive the bar exam. But you might not even need to go to law school. Law clerks can become lawyers without enrolling in law school by completing standardized educational materials and benchmarks under the guidance of a mentoring attorney, along with the 500 hours of work as a licensed legal intern. So, Andy, going back to our founders who we talked about a little bit earlier, folks like John Adams, for example, I believe became attorneys through apprenticeship. I'm not sure it's quite the same education these days as it would be back then, but what do you make of first of all, the argument that the bar exam is basically racist, and also that you don't need to prove your competency through that exam to become a practicing attorney?
Well, look, I think that if you're going to start from the premise of disparate impact, which is, voodoo, you're going to end up at some very strange places. And this is like the next logical place that we've ended up, that any disparity in results has to be the basis of racism and can't be explained by anything else. We've seen it in connection with crime. We've seen it in connection with COVID, like with illness, with various things. So now this is just the next logical thing. I can't say, Greg, that I'm overly offended by the idea that you might not need law school or you might not need a bar exam, and that apprenticeship, look, the bar exam is it's a good metric. I always like a metric that everybody has to take because you get an objective idea of what people's relative strengths are. But, it doesn't have a whole lot to do with being a lawyer, a lot of it. There's a rule against perpetuities that I think I flushed about 90 seconds after I got out of the bar exam. I haven't thought about it in 40 years. So, there are things that, people study to the exam rather than like being a lawyer. And there's a lot that's wrong with legal education in America. It used to be that lawyers were trained by reading treatises and understanding what the law is. And the idea was that the law was what undergirded a good society, a prosperous society, a rule of law society. And then in the 20th century, the law schools switched from that to, looking at the law as an activist tool to do social justice, which is a way of politicizing it. And a lot of the people who, there's very fine lawyers who are from that mold, but there's an awful lot of lawyering that doesn't have much to do with what's true and fair and just, and is just about moving ideological agendas. So I'm not troubled by the idea that if we change the way that we train lawyers and we let the market operate, that you're going to hire a lawyer who is a skilled lawyer, whether he got it by going to law school or by being an apprentice, whether he took the bar exam or he didn't take the bar exam. If you let your results, like the person's results in his career or her career, determine what their worth was as a lawyer and whether they should be allowed to practice, I don't have a lot of problem with that. But my problem is, why would you stop at the bar exam? If your thing is going to be disparate impact, why shouldn't it next be wins and losses? If lawyers are not winning at the same rate, doesn't that mean that the system is racist? And don't we need to like take a lousy lawyer who happens to be of some ethnic or racial persuasion, and don't we have to give him a handicap like they do in horse racing and golf? You know, you get to win this one, justice regardless, because we're doing disparate impact here. I mean, my thing is, why would you stop at the bar exam? The problem is the disparate impact part of it. And if that's going to be your operating principle from Jump Street, if you're not willing to take that on at the beginning and just blow it to smithereens and say we're going to do a merit society, then you're going to have absurd outcomes. But if we're going to rely on merit rather than this other nonsense, then I don't think the bar exam is that important or law school is that important. You know, because merit has a way of coming across one way or the other.
This is the logical conclusion when you replace equality of opportunity with equality of outcomes. And and that might sound good to some people in theory. When you're on the line legally or medically or whatever it is, you're going to have a much different perspective, I have a feeling. So, Andy, always great to have you here breaking down the big stories, and we look forward to having you again tomorrow.
Look forward to it, Greg. Thanks.
Andrew C. McCarthy, former Chief Assistant U.S. Attorney for the Southern District of New York. He is the author of Ball of Collusion. He is a contributing editor at National Review Online, also a columnist there, and he's a Fox News contributor. I'm Greg Corombos. Thanks for listening today. Also, subscribe to the podcast if you don't already. Tell your friends about us as well. Thanks for your 5-star ratings and your kind reviews. Please keep those coming. Get us on your home devices. All you have to say is play 3 Martini Lunch Podcast. Follow us all on X. Andy is at Andrew C. McCarthy. Jim is at Jim Garrity. I'm at Dateline_DC. Have a great Tuesday and join us again on Wednesday for the next 3 Martini Lunch.